give the attorneys and et cetera the ability to comment on each one. Does that work? Or will you on mute?
Yeah, we're good. All right, let's go.
So yeah, let's go. So again, thank you. Cookies, 420, BioTrack, Zuberlawler, Scottsdale Community College, Copper State, Weed Maps, all for your tremendous support of this year's social equity campaign, the educational campaign. We reached a lot of people. I was out at the Earl Cup this weekend, and I realized we haven't reached enough. We haven't shared this information with thousands of people that would otherwise benefit from it. And hopefully the expungement education aspect will go on for a while post the excitement that is involved in the connection with licensing. So, and again, thank you to my sincerest thanks to all of you for your time and your willingness to commit your energies, your resources, your knowledge to helping educate your fellow Arizonans. And yeah, with that, Janet, you want to say a couple words, and then we'll go to Clark, and then John, and then Caleb.
Well, good afternoon, everyone. It's great to be here, and thanks for the invite. I'm Janet Jack. I'm a partner at Zuberlawler. We do a lot of cannabis activities across the country. My specialty is mergers and acquisitions and other contractual relationships of the parties. I'm really looking forward to hearing from you all about how any of us, all of us, can help you with your application for a social equity license.
Clark.
Thanks, Dimitri. Hi, everybody. My name is Clark Wu. I'm a business attorney and litigator with Bianchi and Brandt. We're a full-service business law firm that caters to cannabis clients, not just here locally in Arizona, but also around the United States. We do everything from regulatory compliance to deals of all sizes, to also litigation matters if and when you get into trouble down the line. We've been happy to participate with MITA social equity program since the very beginning, and to help you, become educated and learn about the application process. So we're excited to be back here again today and to, share what we can to get you through the application hurdles.
John.
Yeah, hey everyone. I'm John Udell. I'm a cannabis attorney with Rose Law Group. We're a full-service law firm with the real depth of experience and expertise with the cannabis industry. I'm also a communications director of Arizona NORML. So in that capacity, I volunteered at about 20 expungement clinics over the course of this summer. It's been about 80 hours or so speaking with people who, many of whom are eligible for the social equity program. So that's been a really interesting experience. I'm happy to be here today and share some expertise.
Maxine.
Hi, I'm Maxine with the Cannabis Business Advisors. I'm president and co-owner. We primarily focus on assisting groups with applications across the US. I personally have participated in over 20 different states. And then we do assist with helping clients open up their facilities as well. And then, sometimes with connecting people through for partnerships and things like that. So I'm happy to help in Arizona. Arizona has always had, a soft spot in my heart, and have participated in all of the application processes. So this one's an interesting program. I'm happy to help in any capacity I can. So thanks for having me on here.
Thank you. Professor Tice.
Thank you, Dimitri. Yes, Caleb Tice here from Canna Owners. I'm also an instructor at Scottsdale Community College in their inaugural cannabis program. Also involved in multiple plant touching brands and helping other brands from that have a presence in one state wanting to transition into another state. So there's not a lot of things that I have not been exposed to in my time here in the cannabis industry. I love what I do, and I love being able to solve complex problems and create solutions for my clients, whatever their needs may be. So happy to be here and happy to give some perspective. So thank you.
Tom Dean.
Hey, Dimitri, thanks. Yeah, Tom Dean here. I'm an attorney, been a cannabis attorney since I would put it at about 1998 when I became legal director for NORML. Moved to Washington, D.C., where that organization is headquartered. ended up moving back here to Arizona. My practice since 2009 has been devoted entirely to just cannabis related matters. I co-founded the Arizona Cannabis Bar Association here. I know we've got a couple other members, founding members here also today. And I do primarily criminal defense and administrative law, as well as business matters. And I know been working closely actually with Gary most recently in trying to figure out this whole social equity application process. So this was excellent that you're doing this, Dimitri. Once again, you're right on it. Thank you for having this.
Gary Smith, the founder.
Hello, hello. I am indeed Gary Smith, and I am one of the founding directors of the Arizona Cannabis Bar Association, along with Tom and Janet as well. In addition, I'm a 30-ish year veteran litigation attorney. The last 12 of those years, I've been neck deep in cannabis, well, cannabis practice, maybe cannabis too, but certainly cannabis practice. Along the way, I've represented probably every different facet of the cannabis industry you can imagine, and I'm really excited to be handling the new social equity licenses.
Dr. Humble, Will Humble, would you like to introduce yourself? And then what I'll do is I'll share the screen, your slideshow, and then just tell me next slide, next slide. Yeah, let me see how that's going to work, because after slide 1, then I might just flip back to gallery if I can do this efficiently so that everybody can speak about slide 1. But if you want to introduce yourself first.
All right. Yeah. Thanks, Dimitri. Thanks for the invitation. Always a pleasure to help MITA. My name is Will Humble. I've been in public health for about 35 years. Never been directly involved in the operations of the industry, but I served as the regulator for the medical marijuana program. And one of the areas that I think was the most fun part of being that director of the state health department back in the years where we were setting up the program. So it's a pleasure to be here. And so let's go ahead and roll. You're going to take the back screen, Dimitri, right?
Yep, I'm going to do it right now. And let me just say again, it's humbling to be with all of you. We have a wonderful Arizona community that works together, and you guys are all just, your names are held in such high regard. So I appreciate to be amongst you. Let's see, let's go with this, see what happens. Wait, I need to exit. So I need to share my screen first. Share my screen first. Share my screen. And desktop share. And then I need to make my desktop this thing present. Does that work?
Yep.
I can see it.
Okay, again, thank you to our sponsors. The first screen is, let's see, there.
Okay. All right. So let's go. I'm going to just do sort of the play-by-play here, and then we'll get color commentary from everybody to get some more behind the scenes kind of viewpoints from each of these things. So let's jump right in. Dimitri, go ahead and advance the slide. All right, so here are the final social equity rule application requirements. Many of these are the same as the draft application requirements. There's going to be a few changes that we go through with some of these slides, but one or more of the principal officers or board members of the applying entity must hold at least 51% ownership. So that's an ownership requirement, and the rule goes into what the details of ownership actually means. I think some of the other guests on the webinar here can add a little bit more depth to this. Anyone want to opine about the definitions that the department is using for ownership and the merits or wisdom of including this part of in the final rule?
Well, I'm scratching my head. Can you see me scratching? I'm not sure. I get the point of this. The point was to, and other provisions that you'll undoubtedly review, but the point of this was to keep the license within the social equity community. Unfortunately, as a matter of majority decisions and the mechanics of putting together a company that would become the applicant, most entity organizers and people who join the entity want to have restrictions and certain limitations on to whom they will need to be associated, and the restrictions on their shares or their LLC interests. So I think the department went too far.
Caleb?
Yeah, I would agree. It seems like it's kind of solving a problem that may or may not exist, of like a sort of like a straw buyer situation. I think that's sort of the mindset here of like, but honestly, ownership has always been at 51%. So they're just clearly defining it to where there's not any sort of back end agreements or other things. They're trying to maintain the spirit of the program in with the social equity applicants. So I can understand why it was included. I think it's a little overkill, but it really just shows the what the spirit is behind it.
And I think as we go through some of these other slides, you can see a continuing theme that I think it's clear that the decision makers at the agency were trying to do what they can to try to uphold what they see as the voter intent behind the social equity program, and to the extent they can use their authority to prevent straw buying from happening.
And Gary, I know you're raising your hand. No need to raise your hand. I'm gonna have a little trouble seeing everybody because I'm doing the screen share. So just jump in and opine.
No worries. I just didn't want to cut anybody off and be rude like that. But
No, it's okay.
I wanted to just lend one additional comment so that the viewers and listeners understand this. Prop 207 creates this whole body of law here, is 17 pages of statutes. In all 17 pages, there's literally only one sentence that creates social equity and doesn't even define social equity. So DHS had a real challenge trying to create rules, trying to figure out what everybody wanted and would find acceptable, because really, to be candid, the proposition itself did not offer much guidance.
You know, I sometimes reflect that when the Lord said, "Do unto others as they would do unto you," he could have given us a little more guidance too.
Oh, absolutely. Even just having a definition for social equity in the statute would have been a huge help with this.
Yeah, I just make a little joke there. Sorry. Hey, Tom, did you want to jump in there?
Well, yeah, I mean, I think this is something that the department was being criticized for from the very beginning in their different revisions of rules. For them to take so long before they even attempted to define that, most recently in the amendment to the rules, identifying those certain zip codes as essentially what they think, or in their opinion, are these communities that are disproportionately impacted. Of course, doing that now with only a month and a half before applications are due is a little bit, it's pretty last minute, given the fact that these expungement petitions are taking anywhere from 2 weeks to 6 weeks to approve. So one of the qualifiers, as you know, Dimitri, is that you have an expungible offense. Well, if that's your one of the criteria that you're using to qualify, you better get that expungement petition filed fast, because you have to have, my understanding now is, whereas at the beginning you only had to have the petition pending, now it must actually be approved prior to filing the application. So that doesn't give people a whole lot of time. I mean, if you think that you want to be part of this game, you need to get in now. If expungement is part of that qualifier, you have no time to waste. It's right down to the wire.
All right, we have a lot to go through. Let's, John, you wanted to add something before?
Yeah, I'd like to chime in and really parlay on Tom's point. And I think that's one of the things that a lot of people who are interested in the social equity program don't realize is the length of time it's taking for courts to process petitions. That's important for anyone who's relying on expungement as one of the criteria. It's also especially important for people that have expungible excluded felony offenses and need to get the facility agent license before they can submit their application, because that's got to be expunged from your record before you can even get the FA license. And the release of zip codes is a little bit problematic with the timing of it. Despite that, I mean, so with all these people I've spoken with at clinics, I'd say 80% of the public is generally unaware of the social equity program, period, let alone of the fact that they qualify for it. So as we start seeing, more news articles, like, for example, resulting from the release of the list of zip codes or maybe the final rules, it's just kind of a shame that it's already too late for so many of those people. And I would add to that I am pretty sympathetic to the predicament the department finds itself in, not only due to the vagueness of the reference to the social equity program, which Gary mentioned, but also the amount of litigation that other social equity programs around the country have seen. And I'm sure they were aware of that and trying to do whatever they could to prevent the prospect of litigation. So it's certainly a hard job. And as Tom said, if you're interested in this program, get your stuff expunged ASAP, as soon as you possibly can.
And
And I might mention that applications and all of the data are online. The Arizona Supreme Court has published them. I believe Maricopa County Superior Court and maybe Pima County Superior Court has also published them, and there are the forms, the instructions, a lot of detail. And I understand too that if you file yourself, there's no filing fee. Is that right, guys? John and Tom? So
Yeah, and if I could just parlay from that, Janet, and shout out to Normal John. Obviously, John Udell is part of the state Normal chapter. They're doing self-filing expungement clinics, and they just had one last weekend. I think they've got them coming.
you muted yourself, Tom. That was unusual.
And you want to self-file. I think you should really seriously take a look at some of the clinics that Normal and others are having that can assist you in doing that.
Okay, let's Will's got a great PowerPoint, so let's just blow through that real quickly so we can but feel free to interrupt him. I'm sure he won't mind, because
we'll have an opportunity to talk about expungement again here in a couple slides.
Yeah,
That's what we have for ownership. Dimitri,
and Maxine, Caleb, if you guys can monitor the chat room, so if people bring up important points, you guys can bring it up. Let me go back here.
I've been watching that.
Go ahead, Will.
Yeah, this will be on the MITA website. I don't want to go through the bullets here. It's too much detail. Now here's a new provision. And this is brand new. It was not in the draft. It's a new thing. Again, part of the department, it appears to be theme of trying to prevent straw buyers. Straw buyers meaning, not a real applicant, that somebody, a wealthy person goes out and tries to find somebody who qualifies, makes them the applicant in name only, makes them sign a contract in advance to sell the business if they are lucky enough to win the lottery for a grossly undervalued amount of money, and the person is kind of ripped off. What they're trying to do with this is to prevent that kind of advanced contract. And so this is in the final rules. And again, it looks to me like an effort by the agency to protect the legit people who this program was intended for.
Yeah, but one thing I would think on that is it seems like if it's voluntary and it's very clear that it's like market rate or that there's a voluntary agreement, because I know that there are quite a few people out there that have no intention of operating the business, but see that they would qualify, so they're looking at it as an opportunity for them to potentially get a windfall from this. So I think that that's the big key here is I mean this doesn't make a distinction between voluntary and involuntary.
Nope.
Involuntary. So this just says that you can't have anything in order to. So just.
I just think it's BS. Honestly,
it's more paternalistic that you've mentioned before.
Yes, right. I think it is paternalistic, and I think it's against the majority of documentation that is entered into at the time an entity is formed. But it is clear that this would make the social equity applicant be a social equity applicant forever.
I disagree. I think this says, or is intended to say, that a social equity applicant must always be inside the entity. I read this to say that the original applicant can't contract away their presence if there's no remaining social equity applicant or qualified party, rather, excuse me, in there. So while I can't envision somebody entering into a contract to remove themselves and have somebody else with identical qualifications step in, I think that's permitted.
I
Yeah,
want to
I
just
think
say
that's
that I think
permitted.
this is a all pre-application, so and that's what kind of the focus is. So what the state's trying to do here is they're trying to limit, at least from my perspective, they're trying to limit the types of arrangements that potentially a social equity person can get into, before the application. And
For sure.
as we talked about, the concerns is like the straw man type of relationship, but
Right.
none of this matters at the point of after licensing, because at that point, this whoever is on the license itself are still allowed to engage in voluntary sales. Nothing in the rules prohibit that. So it's like there's a lot of restrictions that the state's trying to put into place now to, for better or worse, I think, try to protect the social equity person. I mean, the flip side to it is, as we recognize, it potentially limits their ability to enter into business arrangements and structurings that they might need to operate their business as a whole. But all that goes away at the point of licensing. And at the point of licensing, whoever holds that license, whether or not you're the social equity person or the other 49%, I think they could freely transfer at that point, and there's nothing in the rules that prohibit that.
Except that there's nothing that if there's no agreement pre-award, it's going to be really difficult post-award of the license to figure out who's entitled to what, when, where, who has various rights as an owner. And how the management of the entity is to be continued. Arguably, people who enter into an application together are joint venturers, but that's essentially a partnership. But without an agreement among those partners, what will we expect? I think we'll be back in court litigating who's responsible for what, how much money has to be contributed by whom, and it goes on.
And then I
It
think
happened
that,
anyway, though.
Pardon me?
Litigation's going to happen anyway. It doesn't. Honestly, it doesn't matter how many. Look, for the folks at home, we went through, 12 years ago, our medical license issuance. A few months back, we had our initial round of recreational, and there was litigation around all of it. And it's expected.
I think there's the other aspect that a management contract. So you're someone who is on the investor end of these things coming in looking for a percentage of the license. That's one thing. But then on the other hand, there's the approach of having a management contract for an extended number of years. So not even necessarily touching the ownership of the license, the entity that owns the license itself. So, I mean, I don't know, that may be a safer mechanism. I know that that's probably what most of these investor groups aren't looking for. They're looking for a piece of the license itself. But a hybrid of those two things is, I think, one way for all the parties to kind of protect themselves if you've got both a management contract in place as well as an operating agreement accounting for some percentage of equity. I mean, that's, I think, the way, in my opinion, the way to go about it to protect everybody involved.
I agree with you, Tom, and I think especially with the change to the education requirement and the time frame that we're going to get to in the presentation in a minute, there's a month for everyone to have taken the class. So I think that kind of mitigates that situation as well too, of having to have under such a crunch with multiple individuals involved of trying to just logistically get that done in a month.
Hey, I was going to add too that the department itself has said that it may change the rules and regs through December 1. So I don't know if we should anticipate more clarifications or backtracking.
That's a good point, Janet. And I would like to ask Will Humble, because I seem to recall him one time saying, you know, the department just wants to write regulations and then forget about it and never bother with them again. This seems to break that mold, Will.
Yeah, so, I mean, we'll see what they're gonna do. As of right now, these are the rules. Janet, what you said is true. They have until December 1st of exempt rulemaking where they don't have to go through public comment or anything. And they could make changes all the way up into the end, including the deadlines. And so, that may be the place to focus some advocacy.
Let's do this. Actually, this makes me want to run for governor and put you back in charge. Will, I'm just kidding. So
Let's do it.
Man's got to have a hobby. So let's blow through this. And then
Let's keep going.
the first subject we're going to come back to is this 51%, because this is obviously a very big topic for people. So at the end of it, at the end of the PowerPoint, we'll come back to the 51%. And if anybody else wants to make a list of topics we need to come back to, I'd appreciate that. So go ahead. I'll click on the next one.
Okay, the training, that part of it, it's the same as in the previous version of the rules. That the principal officers and board members that hold the ownership in aggregate, that could be a consortium of people, need to complete the course. It's online, it's available right now and has been for a while. And it covers laws, regulations for operating an establishment, information about financial backing, et cetera. I haven't taken the course, so I can't tell you, how good it is or anything like that. But the educational training is in place. It's required under the regulations. It will stay a requirement, I'm sure, because it's built into several pieces of the regulation. And I don't know if we need to spend a whole lot more time on this, but
I just want to make one quick point. I think there has been a change, not just in this round, but in the past round of rules regarding the courses. So previously, the state only required the quote unquote social equity, person to take these classes. Now I think it's everybody. If you're on the license application, you're going to have to take the course by November 17th.
Unless you are a co-op or an association. So with a co-op or an association, you only have to have the executive director or whoever is the person in charge of the entity is the only one considered a principal officer. For all LLCs, it's all members, it's all managers that all have to do it, which is more to Tom's point about with the management companies about that also being able to just create a level of separation there. But that is a big change, and it says each principal officer and each board member. So it looks like that is actually a very, very big change. Thank you, Clark, for mentioning that, because that's huge.
Yeah, and remember also, there's a separate regulation that more broadly defines principal officers beyond just true legitimate officers.
Right, we'll get to that a little bit more depth later. Go on, Will.
So basically, when in doubt, take the class.
So take the one in October, because there's one coming up, I think, in like 5 days, and that's the only other one I've seen on the calendar.
They should have had me
this weekend.
There would have been some comic relief in there, Go ahead, Will.
All right, next slide. Okay, so this is the set. This was from the previous rule as well. The application requirements, the felony exclusions. So this says what you can't have in order to apply. And these are Title 36, 901, 03 are some violent crimes. You just have to look at the list of these crimes really to see if they're a disqualifying felony offense that would not allow you to be an applicant. Anybody, is pretty straightforward. It's a long list though.
Well, let's see, the easy way to do it, Will, is a violent crime is a felony that involved physical injury or the use of a weapon. And a controlled substance offense is just what it sounds like, except for an offense that would have been within allowable amount prior to 2010. I guess, right? We're still talking about prior to the Medical Marijuana Act, that would have been, if the person was a patient, would have been within that person's rights as a patient. That's basically those are the categories.
Next slide.
So just to throw out an example, a marijuana offense that was 3 ounces less than 10 years ago would be a disqualifying offense, right?
Mhm. Yes, yes, that would be.
But if it was 1 ounce, it's not disqualifying.
That's correct. If it took place prior to, I think we're still dealing with prior to the effective date of the Medical Marijuana Act. So prior to 2010, had it been under the 2.5 ounces, then I think it's the opinion of the department and everyone else that that would not count as an excluded felony offense.
All right, so the take-home message for applicants on this is to pay attention to that list of disqualifying felony offenses. Take a look at your applicant's set of prior convictions and when they happened, and be careful about, knowing that in advance so you don't waste a lot of time when that applicant may have had a disqualifying offense. So it's in the law, but it's just something you need to pay attention to.
All right, I'll go next slide.
All right, let's go to the gating criteria. So these are the things that you have in order to qualify to apply. The department has put together a set of criteria that you need to meet. 3 out of 4 of the criteria are the things that you have to meet the conditions of 3 out of 4. So you don't have to have everything, but you need 3 out of the 4 following items. And it might help, I think, Dimitri, if we go through these quicker.
Yep.
Because it's 3 out of 4, and it'll be easier for people to remember what they were. The first gating criteria is household income. Have you had a household income in the last 3 of the previous 5 years of less than 400% of federal poverty? So that's the Health and Human Services policy, federal level. That's published. You can look it up online. The second is you need to have a previous marijuana conviction if you want to meet, if this is one of the criteria that you want to use, that you are eligible for and petition for expungement pursuant to the law to get your conviction expunged, and or you were convicted of a violation of a federal state law related to marijuana, and you could look up that in 2862. Now, remember, we had said a few minutes ago that you have to have your expungement cleared, and that's still, it has to be finished. And while this gating criteria says eligible for, in order to get your, what did you call it, the VF? The
FA.
Facility agent card.
Yeah,
FA
facility agent card, your expungement has to be cleared. That's a requirement of the applicants. So in effect, you need to have that expungement cleared in order to put in the application as one of the principal officers of the ownership group inside this. So previous marijuana conviction will help.
There's a question that's in the
right
chat room about vacated convictions and civil rights restored. I didn't know if the attorneys could chime in on.
Yeah, sure.
How that
Unfortunately,
distinguishes.
that was a case of mine at the Court of Appeals. I argued that conviction set aside no longer was an excluded felony offense. Unfortunately, the Court of Appeals disagreed with me on that one. So setting aside conviction under the old set aside law and or reinstating civil rights has no effect on the status of that conviction for the purposes of having an FA card or any other type of registration.
What about for like the offense? Like, let's say that I think it's that you had a conviction, but then it was vacated. So how does that work as far as for qualifications? Does that still show as far as that you had it expunged and then you would still be eligible because you had your conviction vacated?
So all right, maybe we might be talking about 2 different things. An expungement under the new law, under Smart and Safe, an expungement is different from when you hear someone talk about having a conviction set aside or vacated. That's
Okay.
A different law that does an expungement does have the effect of clearing that so that it no longer is an excluded felony offense. A set aside does not have that effect.
Gotcha. Okay. All right. I think that's what the question was. So
If you guys wanna-
Yeah,
Right
Dimitri,
now-
let's go to the next slide. And
Yeah.
this is, I think this is a new one coming up.
Yeah, Matt, Maxine and Caleb, if you can write down these questions, we'll answer everything at the end. Is that cool?
Yeah.
I just wanted you guys track this stuff so we
Yep.
get that speed round. Okay, next one.
Okay, so we've covered 2 out of 3. Oh, this is the same one. This is a criteria that was in there before. This is if you've got a spouse, family member, the rules list the exact relationships of those persons that may have had a conviction earlier, that can qualify you. This is where it says spouse, surviving spouse, parent, child, sibling, legal guardian, convicted of a violation, marijuana prevalent. Now, this doesn't require expungement or anything. This just it goes to show that your family members have been, disproportionately impacted by the prosecution of marijuana laws. So let's go to the next one. So this is where this new for this part of the rule. One of the 4 gating criteria is lived in a community disproportionately impacted by marijuana laws. You have to have lived 3 out of the last 5 years in a community that's been disproportionately affected. The Department of Health Services listed a set of zip codes that they believe are the ones that have been disproportionately affected by enforcement of marijuana laws. The next slide goes into, it has the link to it. So go ahead, Dimitri, and and so if you go to that link that's in orange up there, it'll take you to the list of the zip codes that ADHS says apply as part of this gating criteria. Again, you need to demonstrate that you've lived for 3 out of the last 5 years in that zip code. And I'll just do a quick editorial comment here. The state released the method. I've been beating them up on Twitter a little bit for just posting zip codes with no explanation of how they drew the conclusions that those were disproportionately affected by marijuana laws. And I think that's poor governance. That, if you're going to put something out, put out a document that defends and explains how you came to that conclusion. They didn't do that. And then finally today, they just put out a 2-sentence explainer, not a document with methodology, data sets, conclusions, or anything like that. They just said that they had 2 criteria to make these zip codes up, that if the zip code was in aggregate, more than half African-American, Hispanic, or American Indian, and the population in that zip code, more than 25% of the people in that zip code participate in the SNAP program. Now it used to be called food stamps. That's the list of zip codes. Now, they say that the agency says that, and without displaying evidence, which I put in parentheses here, racial groups excluded from this were not this. In other words, they just say, that's all I just put what they said. I'm not going to defend it or explain it. And somebody put in the chat box, Native American, I wrote what they wrote on their website. They said American Indian on their website. So that's what I put up here instead of Native American. But, it seems to me they had plenty of time to do this. They took months. They could have done this in one day, but instead they took months, and they didn't look apparently at, disproportionate the behavior of prosecutors. It's all water under the bridge. This is their final rule. I just think it was a pretty primitive way of.
What's interesting, Will, is exactly that you said. They could have done this in one day. And actually, a reporter called me and was doing a FOIA to figure out how much they paid to get this done in one day. So I'm curious how they'll do that FOIA and find out. But I bet you it costs a lot of money.
And isn't it interesting too that North Scottsdale was included in the list?
Yeah, and no place in Flagstaff and other parts of the state where you would think that there were communities that should have qualified. But does anyone, I know that a lot of us were talking about, we didn't think the department would be so bold as to actually make an ethnic category or base these communities on ethnicity because of the potential for lawsuits under federal and state law. I mean, does anyone have an opinion on whether we think we're going to see any lawsuits that are going to attack these?
Yeah, this has nothing to do with the impact of or the enforcement of marijuana laws. This is just solely based off of a background, and then SNAP benefits is already covered under income.
Yeah.
So I'm a little confused about it. This is the first time I've actually seen that the methodology. I didn't see that it was released earlier today or whenever it was released. And thank you, Will, for helping to get that information out there. Yeah, I'm kind of at a loss for words, I guess.
Any other, Clark, since you're at a loss for words, Clark, Gary, any
Yeah,
thoughts?
I first off, I agree with Caleb. I do not understand why the SNAP benefit thing is part of this criteria. They already have a financial income criteria. So this is like a double. And also SNAP has nothing to do with cannabis or discrimination or disproportionate enforcement. It's a complete non sequitur. Also, I can't remember who asked about litigation coming out of this, but yeah, this logically something like this begs to be litigated. But on the same token, we all have to remember that the agency here, DHS, has pretty broad discretion in drafting its rules. And when it's trying to model off of a statute that is virtually contentless, that gives the agency tremendous latitude. So while, yeah, I do expect somebody's going to pull the trigger on a lawsuit, I think they're going to have an uphill battle.
Yeah, they're doing the best they can, obviously, but it is our right.
Yeah, no, I think that's a terrific point, Gary. As the regulator, you look at the direction that the voters gave you, and it's practically nothing. And so for somebody who wants to challenge the agency on this provision, that's a pretty tough hill to climb because they don't have a statutory standard that they have to meet.
I think we've seen ACLU reports.
Yeah.
On the incidents,
Like arrest by zip code, right?
Yeah, arrest by, I don't know if it's arrest.
No.
Prison sentences.
I can speak to that. A year and a half ago, ACLU released a report, and you can get this online. Just do a Google search for it, you'll find it. And it regards arrest rates for cannabis amongst different races. And in particular, it tracks Black people, African Americans. And what it found is that nationally, Black people are arrested and charged with cannabis crimes at about 3 times the rate of their white counterparts. And in Arizona, it's even worse. And on average, Arizona has roughly half the population of Blacks than the rest of the nation. So our record, our statistics are horrendous on this.
Will, what would you have done had this fallen on your lap?
I would have, even though I had the full latitude, because there is such a lack of clarity in the statute, I would have looked at 2 things. And I would have had a contractor do it because there's no one in the agency that's competent to do this themselves. But look at 2 things: the arrests and the convictions. The behavior of prosecutors needs to be part of this equation. Not just, over-policed is the kind of word that gets used, but to me, the egregious behavior is also equally, if not more, on the prosecutors by the way they treat lower income and people of color when they know they can get away with these things where they make people plead to things that are egregious and by scaring them. And so, and they have public defenders defending them. And so I would have gone after both police arrest records and prosecutorial behavior and the outcomes thereof and drawn some conclusions with that rather than just looking at race and income.
Well, I agree with that. And I think that here's the thing. Yes, if you focus on communities that have a higher Black and Hispanic population, more than likely those communities will also have a higher arrest rate for marijuana related offenses and other types of crimes as well. But I wonder why why the department didn't just say, well, let's look at communities with higher arrest rates, knowing that probably the communities that they find in large part would be communities that have larger populations of Black and Hispanic people, and just focus on that rather than tie it to particular ethnicities. I think I don't know. I think that's what the ACLU advocated for back during the drafting during public comment period for the regulations. And I mean, that would have made more sense. But I think anytime you're making these ethnic categories, it invites scrutiny and complaint for discrimination. But I don't know. I'm just at a loss as to why they didn't just use. It's not that hard to do. Arrest statistics are available according to communities, and why they chose not to do that instead, I guess, you could say, I mean, I don't know, a little lazier by just saying we're just going to pick these categories. I don't know. It's a little troubling. I mean, I'm glad it's better than what it could have been, but I think at the same time, it's somewhat problematic from a legal standpoint. And I agree with Will. I do agree with Will and Gary that, it's an uphill battle anytime you're going to try to challenge an administrative department's discretion when there's very little, guidance in the statute. But at the same time, the one time that you can challenge these things is when you've got what appears to be, some sort of ethnic-based discrimination. So, we'll see. But
John?
Yeah, just chime in really quickly, and I think that's basically right. It's tough to prove they abuse their discretion, but it's interesting that Arizona has a constitutional prohibition on affirmative action, like many other states, and that's why so many states do exactly what Tom and Gary were advocating for, which is looking at arrest data to serve as a proxy for race. So I know Ohio had one that was based purely on race several years ago, and that ended up being overturned in court. I don't know that I'm necessarily, opposed to that in theory, but I think the way they did it here led to some really surprising results, and not just the South Scottsdale zip code that I believe Janet was referring to, but also just the fact that so many of these zip codes are on tribal reservations. And that seems to conflict with what Prop 207 says, communities that were disproportionately impacted by our previous laws, because for the most part, our laws aren't really being enforced on tribal reservations. There's tribal law out there, and tribal law enforcement. I don't know, maybe Tom has some familiarity you can shed some light on with that. But I thought that was kind of fascinating that there's a number of zip codes that are on this list that I would be surprised if they had disproportionate state law arrests for marijuana.
No, I think that's really good, John. I mean, you're right on that. I mean, it's sort of like identifying ethnic groups that have disproportionate arrest rates for marijuana offenses. But the fact is that on the reservation, in those actual areas, geographic areas, you're going to have much less marijuana related arrests than in communities that weren't identified. So I think that's the troubling part of it is that a lot of these communities, like someone said North Scottsdale, I mean, come on. And yet the east side of Flagstaff, nothing. And having practiced up there, I can tell you that there's a huge inordinate amount of marijuana related arrests in that community. But so it just seems to lead to some odd results here, their approach.
Let's come back to this as topic number 2 of our last 2 topics. We'll do the 51%, and then the communities of interest. We'll have a little bit of discussion. Let's just get through the rest of the PowerPoint quickly. We're at number 12. Will?
Yeah, go ahead, Dimitri. There's just a couple more.
Yeah.
This is the same as before. So we're finished with the gating criteria now. Again, you had to meet 3 out of the 4. Everyone has to take the class now. Remember, that used to be a gating criteria in some of the previous drafts. And applicants must establish that principal officers and board members can't be removed from their permission without their consent or a court order. That's the same as the previous. I don't think we need to spend a lot of time on that one. Application limit's the same. So the principal officers and board members applying can be a member on no more than one other. So total of 2 applications. Am I right about that, you guys?
Yep.
I'm reading that right.
Yep.
And I think that's one more slide, Dimitri, but, community benefit. I was hoping that, at least for me, I was hoping that there would be a little more structure around the future business models of these 26 licenses. And in the end, they didn't do that. I know some of you disagree with the need for that, but I think that in perpetuity, there should have been something different about these licenses over time, and there's really not much different. They're not going to be any different, really. The licensing fee, the application fee went down by $1,000. That's it. That's the whole shoot match.
And this will be on our website within a few minutes if anybody wants to check out the PowerPoint that you created. And let me.
I always throw in that because I know it's going on your website to drive traffic to the expungement opportunities.
Yeah, well, I mean, we were at the Earl Cup, and and it really shocked me how few people knew about the opportunities available to them. And then they're asking about where do I get the money to apply. $4,000 is still a substantial amount of money for a lot of people. And I realized it's 51% thing kind of limited their choices, limited their options. And there's lots of groups out there that are willing to invest the $4,000 and partner with a social equity applicant. But I think that's going to change now. And that ties back to the 51%. Clark or John or Caleb, do you want to comment on this issue?
Just to quickly add on to it, I think it kind of expands upon the 51% component. I think the aim of the department in implementing these type of limitations is to, I think from their perspective, to protect the social equity applicants, but they actually take it one step further. Something we talked about is that essentially the ownership, quote unquote, of the social equity person, can't be contracted around before licensing. Meaning you can't enter into really any type of contractual arrangements that would take away their financial interests, their voting rights, or even compelling them to a future sale. That looks very much problematic now. But the state actually goes one step further, and they say they actually make you attest that not just social equity person, the 51%, but everyone that's listed as a POBM on the application, meaning if your name shows up on the application, you can't enter into any pre-arrangements to regarding the sale of your ownership interest in the applicant. So, in doing that, the state does more than just say, hey, you social equity person can't contract around this. It's everyone. If your name shows up on a license application, potentially what this means is you won't be able to, arrange for any type of quote unquote pre-sale of your management rights.
Does it say that about the management rights, or is it just about the actual equity interests? Because I think that's part of what we were talking about. Is that
I think there's two parts to that, right? So one is there is a provision that specifically talks about self-ownership interest in the license itself, prearranged sales. That's separate from the protections regarding the ownership interest of the social equity person. But in that regard, I think even if you enter into an arrangement with some type of management entity, that potentially, quote unquote, strips away at the ownership of the social equity person, right? Because ultimately, what the ownership restrictions say is you can't enter any type of arrangements that take away their holding a financial interest in the entity, and potentially that could mean through, having any type of management entity or management arrangement, unless that social equity person also holds the same level of power control as through in this management company.
How do we suppose they're going to check this requirement? Do you suppose it's going to be an attestation?
Yeah, it is
an honor system.
It's an
Oh, an
attestation.
honor system.
Yeah, so it's another form that you're going to fill out.
It's an attestation that if they later find was a false attestation, then they could potentially.
Yeah, then it's very serious. That's attestation's a very, it's.
Yeah, well, you've got two problems there. One, you'll blow up your license, and two, if it's a sworn attestation, you could be facing a felony.
But and this it's just frustrating because we know there's a lot of unscrupulous people in this industry, in this game, And if DHS doesn't, I mean, there'll be plenty of people that do what they want to do, thinking that DHS is not going to come back and double check in the long term and just hedge their bets. And that's just kind of an unfortunate result. Sorry.
But I can tell you, Dimitri, the tips come in. It's not like the agency figures it out on their own. Someone who's disgruntled, who feels gypped, is the person who tells the agency the who, what, when, where, and how you can find it of that. So
Yeah.
But I have to
people do come
wonder,
out of the woodwork if they feel like they've been wronged. And so that's where the tips can come from.
but I have to wonder how the qualifying member, the 51 percenter, is going to feel about getting paid shortly after the license has been awarded, getting paid $1 million, 500,000, 10 million, whatever. I've got to believe that that person is going to be thrilled to get that kind of money. So would that person challenge the arrangement that occurred post-award? Maybe
If
if
they're
he
getting
or she-
enough money that makes them happy, I would say
Yeah.
probably not, Janet.
Yeah, and
Doesn't that
it's,
suddenly become the big argument between two people?
Oh, yeah, true.
And then don't forget pissed off spouses, pissed off employees. For sure.
You know, it's funny things. I'm thinking of this, and Bianchi and Brandt and Zuber Lawler and Gary Smith and Rose Law Group and a few others will end up being the ones litigating all this stuff.
Oh, probably. But in fairness, though, I don't share the panel's extreme dire pronouncement that you still can't do some things with management contracts, because you've got to look at this in context. The rules as DHS has chosen to draft them, and let's be clear, this was a choice. They chose to do it this way. This program is now designed by DHS to require that there be a poor criminal from a bad zip code. So by definition, the most important person on the application is also simultaneously, sorry to say it, the least qualified. They don't have the money, they don't have the education, they don't have the resource, they don't have the experience. And they're suddenly supposed to now come into ownership and operation of one of the most difficult and sophisticated businesses in the country under one of the most arduous bodies of regulation that is still at least federally illegal.
Well, now, Gary, you're forgetting that they do have to take that class.
Oh, that's right. Let's clean that up. Yes, a half an hour to suggest you are now a cannabis expert.
Right.
But you know, look, none of that fixes any of this. So if by definition you've got somebody who has to be there who really can't get this rocket ship even to the launch pad, let alone in orbit, then you have to have other people. You have to have investors. You have to have experienced people in the industry. There's no path around that. Otherwise, 26 licenses are going to land in the toilet within 6 months.
Right, right.
And
Agreed.
it's worth noting, you know, the clock is ticking too as soon as the license goes out for approval
Right.
to operate, right? So you've got to get your property, you've got to make sure it's set up right for a
Right.
dispensary, you've got to get the conditional use or special use permit,
Yeah.
you got to hire staff,
Millions of
get the
dollars
product.
and millions
Yeah.
trying to get all that done.
Couple million, I'd guess.
Immense expenses.
Yeah.
Oh, God, yeah. Yeah.
Could we talk, well, we just have a few minutes left. Could we talk about the administrative review and then we proceed to the substantive review by the state?
Will, do you want to expand on that?
And what that means?
Yeah, so I'll just give the basics here without going into a lot of detail. So, instead of well, let me put it this way. The administrative review is just a check to see if you turned in everything that was required, not the quality of what you turned in, but did you respond to what's required administratively in the application. And so in state government, DHS has this administrative review process, and it's the same thing for a nursing home or an assisted living center or a childcare facility. There's an administrative review of your application, and then a substantive review, which goes into the detail as not just did you turn it in, but does it do everything that we required it to do? Does it have everything that it needs to have? And so I didn't even look at the licensing timeframes, but usually the substantive review will be a lot longer
Yeah.
than the administrative review. And I'm sure that's what they did with their licensing timeframes. When you look at the rules and you see the licensing timeframes, that's a state law that was passed back during the Napolitano administration to put agencies to account so that they don't let applications slide, that you hold the agency accountable for performance, timely performance for all these licensing activities that happen in state government. And it came about incidentally because ADEQ was not processing what the applications for septic tanks and this kind of stuff in a timely manner. And so state government is now held accountable. And that's what those two things are.
Yeah, if you kept hanging for a septic tank, you'd be upset.
Excellent. Do we want to talk about the 51% aspect at all? We have the two big topics, 51% and the ramifications and the communities of interest. And Paul, we can talk about policy aspects of it as well. Do we want to, how do we want to proceed here? Caleb? Yeah, Professor
I was
Caleb.
answering something in the chat room, so you kind of caught me off guard there.
All right, no worries.
Hey, Dimitri, how about we do this? Let's take off these hats and say, if you were providing advice to a potential applicant, what are the A-list items for them to do like right now? What are the B-list items that they need to get into motion? Like as a practical matter for a prospective applicant, what do they need to know about like right now?
Take the class, get the class done. You have to have the class done. It's
Yeah,
and expungement,
expungement.
Yes. Thank you. Yes.
And
those.
I'd get out there and look for sites because I think sites are going to be very difficult to find, given the fact that many of the communities have essentially zoned against anything but a dual licensee, medical marijuana and adult use licensee. And so this set of applicants for social equity do not qualify for the dual licensee permission to locate in those communities. And those communities were fairly widespread.
Yeah, one additional thing to what Janet just said, by the way. You're already late if you haven't started looking for real estate yet. You're already late. Besides the zoning closing up, there are speculators out there right now, locking up real estate. They're getting option contracts or doing outright purchases, anticipating that at some point, one or more of 26 lucky individuals are going to come knocking, looking for that real estate. And oh boy, are you going to pay a premium at that time. So
And yeah, it's probably a good point to point out too, that you're not just talking about one location for your retail outlet, but you're going to be likely looking at an off-site cultivation facility, potentially an off-site manufacturing facility. So you're talking about potentially 3 locations that you're going to need to find, 2 at least, if not 3.
But just a reminder, there's no requirement for that to be on the application.
That's right. Yeah.
sure.
Right.
So you will need it to eventually, obviously these are things you're going to need to be able to operate, but for your application, you need to have the course. I just posted the link in the chat room. It's at the point now where it's online and self-paced. So there's just get on, get it done, because that has to be done by November 17th. So that is your deadline for anybody listening that hasn't already taken it. That should be your first and foremost.
So your two for the listeners, your 2 A-list items are take the Department of Health Services class and get your expungement in immediately and follow exactly what you're supposed to do with that. Your B-list items are things down the road. The real estate some of you have talked about. Any other B-list items?
Can I give what might be an A- or a B+ item?
Sure.
Facility agent.
And this is speaking as a lawyer who's going to be filling out applications for people. Get your documentation together that proves your criteria. You're going to prove that you're, at or below poverty level. You're going to have to prove where you lived. So pull those records now because you don't want to be doing it at the time of application. And what do I mean by that? I mean, you got a lease where you were renting, get that lease. Get, utility bills, show you live there. Bank statements, tax returns, get those together because at some point you're going to have to show them the DHS.
Yeah, that's right. That's definitely an A-list item as well. And I would add I'd add another A-list item is that you need to get your LLC, your entity that's going to be applying approved, as well as the operating agreement connected to that entity. That is definitely an A-list item. You can't go into this without already having all of that in place. And that is can be a little bit time, not to getting the LLC, but the operating agreement, your partners, that can be a little time consuming, and that's likely going to involve finding a lawyer, hiring a lawyer. So I would put that as an A-list. So yeah, those four things, the class, getting your expungement filed, getting your LLC and operating agreement squared away. And what was that last one, Gary, that you were just mentioning? The
Paperwork.
Documentation.
Proof of residency.
Right.
Yeah.
Residency.
Or if you have a family member, if you're qualifying under because your spouse, brother, uncle was convicted of marijuana, get those court records so that you're able to turn that in and improve that you meet that gating criteria.
And
Yeah,
that you're actually an immediate relative. So that could involve birth certificates, that sort of thing. It's unclear exactly how you're supposed to prove that, but that's documentation that, the department's it's not going to accept you telling them that this is my sister.
Yeah.
Yeah.
During the last training course, they had mentioned that it would likely be copies of birth certificates. And then obviously if it's your spouse, then it's just copies of your marriage license. And then one more thing to add to the A-list, obviously after you get expunged, or if you're not relying on that, your facility agent cards, because you're gonna have to go through like your fingerprinting, submitting that to the department, and then obviously getting the approval. So that was something that was time sensitive during the last round that people should be cognizant about this time around as well.
And regarding the conviction order too, don't just get your family members. If you've been convicted, get your conviction order too, either so your family members can use it or because you might not need to get expungement done. And there's been a lot of hand wringing about expungement during this call. I think for good reason. But just keep in mind, if you've been convicted of a misdemeanor marijuana related offense and you don't have any excluded felonies to expunge, that should qualify you under the direct personal impact criterion. So it could save you a little bit of time. I mean, I would still urge you to come out and see me in the expungement clinic anyway to get it off your record, but that shouldn't be necessary for you.
And then, of course, you need the application fee.
Yes, which is going to be a struggle for a lot of people.
Oh, yeah.
Made even more of a struggle by the recent changes. So let's do this. We could talk about the public policy of the communities of interests as is defined. We could talk for that for hours probably. But what I will do is each of you guys pick one topic. We'll start with who wants to go first, and then we'll talk about that topic and close it up. Say I'm Tom Dean. This is the most important topic for me, and then we'll just go through everybody and we'll shut it all down. If there's something we missed, somebody bring it up. And if there's nothing that we missed or nothing else we should talk about, just say I'm Tom Dean signing off. I'll see you. And where is that a curtain behind you?
Yeah, this is my home studio.
All right, Tom Dean, any final thoughts or any final subject you want to cover? Then
Well,
we'll go to Caleb.
No, real quickly, I think it would be nice, maybe Dimitri, I know you've been taking copious notes there. If we could you could put out a bullet point on those A-list items for everybody, so that I think the most important thing right now is for people to understand, well, what do I do? What steps do I take? What are the most important things right now? And I think having that bullet point will help people kind of focus in their plan. So that I think is really, that's been a great benefit of this discussion. So I think MITA, if you could get those bullet points out to people so that they know where to start, because I think that's where everyone really is just wanting to know what do I do now? What do I do next? So yeah,
We're gonna try to get media to link to this particular seminar so they know who to reach out to and get this information. I'm trying to get AZ Central to post about this a little bit more in depth, but we'll see what happens. But thank you.
Yeah, and if I could say too, thank you to MITA, thank you to Dimitri. Not only is he a beautiful man, as everyone can tell, but he does a hell of a job in bringing talent together and having these discussions, which is invaluable. So I can't. Thanks again, Dimitri, for doing these broadcasts, because they're really important, and I always learn something too. So.
Well, I appreciate you, Thomas, like looking in a mirror. Caleb. Caleb.
Yeah.
After Caleb, then we'll do John and then Clark.
Well, yes, thank you, Dimitri. It's always a pleasure being here, and I love getting the additional perspective and seeing different sets of eyes and how the panelists view the rules. And I always learn something on these, so it's always a joy being on here. So biggest thing for me is just remembering everyone, if you don't get a license, there's still plenty of opportunity in the industry. So search it out. It's out there.
That's actually fantastic, Caleb. Thank you. Love when you say that. Do Clark. Clark, final thoughts on you, Bianchi and Brant. We love you guys. I saw you on the teaching seminar. I think Laura was on there. Was anybody else asked to teach and share their knowledge? Just Bianchi and Brant? All right, no big deal. Clark, you want any thoughts, any subjects?
Yeah, I think we covered a lot today. I guess I see one question in the chat box, so maybe I'll answer that.
Sure.
The question is, does anyone have a list of towns, municipalities are willing and ready to zone buildings for social equity license holders? I think that's going to be an issue for a little bit down the road that a lot of people are going to have to address. When most, if not all, cities and towns in the state, when they enacted their zoning and local ordinances regarding, adult use, I don't think they contemplated social equity in any form. So it's not really reflected right now in any shape or form, I think, in the zoning ordinances, which could potentially pose issues and hurdles down the road for people looking for property. But that's not to say, things won't change. And potentially, down the line, when these licenses are out, I'm sure there'll be a push and movement for some of these cities and towns to budge on their adult use restrictions to hopefully at least allow social equity license holders to be within, their territorial borders. Other than that, I would just say, I'll echo what everybody else said today. Timing is short now. Mm-hmm. The classes that you have to take, have to complete them by November 17th. So I would even say, think of that as your qualifying date, because if you haven't done that by the 17th, you're kind of out of the race, unfortunately. So this is a time, do everything now, get your expungement, get your classes, get all the documents together. If you need help, there's a lot of great people on this panel who's been here to assist you and have the resources to help you get this done. So thanks everybody. Pleasure to be here. Thanks, Dimitri.
Yeah, and John, you're next. And Bianchi and Brent, we wish you guys great success. You guys are tremendous assets to the community. Just real quickly, it was like pulling teeth watching the city of Tucson table the social equity aspect of the zoning restrictions that the social equity applicants would go through. And I was just sitting there thinking to myself, how the real world works and how those city councilmen are probably being lobbied to not allow in social equity applicants in any sort of capacity at this point by those who have interests that they're trying to protect. That's just the reality of the world. And I pushed the city council members to include the social equity applicants into the zoning, but they just didn't know what to do. And they thought they could influence the process at the state level, which is often a mistake of city councilmen and local jurisdictions and states. You guys know this stuff. And it was just it's just sad. It just really is sad. But anyways, we'll just keep going. John, and then Janet. John,
thank you, Dimitri. Thank you, everyone else. It's really been a privilege to be on such a great panel. I guess my closing thought too, just to reinforce again, is to get expungement done as soon as possible if you're someone who needs it. I've seen people who have come through our clinics, it's taken them up to 2 months to get expungement done. If that's the case, you're already past the application deadline. And that's even assuming there's not going to be an appeal of a wrongful denial. So you've got to hop on that right away. It would be really a shame to go through the whole process and just be, checking your phone for the update every single day as you get towards the end of the deadline. So I wanted to reinforce that. Also agree with what Clark said. The zoning is really important. I know Payson has just changed their zoning to allow for establishments, and Arizona Normal played a really big role in that. So if you're someone out there who's worried, be sure to let us know and loop us into the fight to get some better zoning laws around the state. And with that, I'll throw it back to you, Dimitri.
Yeah, no, and I will go anywhere and testify in front of any council and explain to them how silly and ridiculous they are if they're enacting things that are restrictions. And if anybody has, any sort of ulterior motives or agenda, I'm sorry, we're on the opposite side. So after John, Janet.
Thank you. Thank you all for being on this very special webinar. I appreciate what you do for the community. Thank you. I just wanted to add, not beat a dead horse, but add another comment with respect to zoning. I've represented young Hispanic men who felt that they would be ideal candidates for an application. And they scoped out some of the towns that they grew up in. Towns were out in the rural areas. And they've actually spent a lot of time talking to local town officials and have given town officials budgets and pro formas and information about how they could add to the employment scene in the town. And believe it or not, one of these towns actually changed its ordinance to permit an adult use license. So it's possible if you have that dream and you pursue it full-time, and it's possible because you provide a real benefit to some of these outlying areas that don't have alternative employment opportunities. Particularly if you can get a license, then you can go out and also be looking for cultivation. There's a lot of rural country in Arizona available for farming, whether it's indoors or outdoors. But the point is, don't just listen to us negative naysayers. You can do it. You can get these smaller communities who are dying for additional labor, additional employment opportunities, additional taxes. Try it.
Yeah, no, Janet, that's again, hope is Yoda jumped in when you started talking about hope. He joined the conversation over here. He likes hope. But yeah, you're absolutely right, Janet. And of course, never forget that your knowledge that you might have attained this year and that you're learning on an ongoing basis, maybe at Scottsdale Community College with Caleb, there's a big earthquake-like moment coming in the cannabis industry called federal legalization. And it might knock some things around, open up a lot more opportunities, or maybe not. We'll see what happens. And so this industry is going to change a lot. And of course, international commerce as well. But those are still to come. Let's go Gary, then Maxime, Caleb, and what will close us out. So Gary.
All right. Well, as always, I thoroughly enjoy being on these panels. I'm a little misty that we're going to be actually having social equity issued. We won't do these panels anymore, so we'll have to come up with the next thing.
We will find something legal to talk about, Gary.
Oh, there's always the next thing. There's always the next thing. So on that point, since everybody's talking about zoning, I will remind everybody that even if you have a town or a municipality that has enacted a prohibitive zoning ordinance, you have a method to petition them to grant you, if not a full-blown change to that zoning ordinance, maybe a variance or a conditional use permit. So don't lose hope. Also, don't forget, just because you're from a particular community doesn't mean you have to open your doors in that community. You're going to be free to open your location anywhere you can find a place in the state. So if you're up in Lake Havasu and you want to open down in Mesa, you might be able to. And then final thought, although we've talked around a little bit today about the possibility that one or more lawsuits between now and I guess December or January get filed, don't rely on that. And certainly don't rely that a court would issue an injunction to stop the program from moving forward. It could happen. So, maybe, but just assume the current schedule is written in stone and will remain unchanged. So move forward accordingly.
Yeah, and speaking of that, our October 27th MITA, we're going to have one of those 15-20-minute stand-up panels on interstate commerce. So if any of y'all want to opine as to what the tea leaves might say or whatever the impact might be, I'd love to have you. Right now, we have Robert Mandel from Super Lawler, John from Dispo, and Mo from iLava Downtown, and we could use one more person. So maybe on the October 27th, just DM me, text me, whatever. Let me know if you guys want to jump in. You guys are always welcome to speak at MITA. And I know John will be speaking on behalf of Normal there as well. Maxime?
Yeah, thanks so much for having me. I know I was really silent, but quite frankly, like, know your place, right? And honestly, this application process, is, mainly, would help benefit from attorneys, my point is. And so, MITA has obviously allowed for that platform. And I mean, there are some really seasoned attorneys here that know what they're talking about. So that's really amazing. Dimitri, thank you so much for obviously putting this together for the social equity program. Bringing it back to the applications, I would say, focus obviously, to everybody's sentiment, timeline wise, on things you can't control. Yes, the training is important. You have until November 17th. That's, a month, roughly a month from now, but you can really knock that out in a day if you really want it to, now that the modules are, live, and, you can take that whenever at your convenience, basically. So I would say, definitely, if you're relying on the expungement process as one of the qualifications, go to one of these cannabis clinics or expungement clinics. I actually had the opportunity to, witness John at one of his clinics, and that was amazing, and it's really helpful, and he can answer a lot of, questions that people might be needing assistance for, but not necessarily have the funds to, hire an attorney to help them through that process. So I would say that would be your first step. Then look into the facility agent card process, because again, that's not within your control. The department has to approve that. And then, training. So those are your 3 steps, I would say.
Well, Maxine, I know you're an expert, and your group is an expert in applying states. Doing the application process for the specialized licensing in other states. And Arizona is not so much a merit-based state, but there's lots of money to be made in specialized licensing. And
For sure.
even though it's an economic abomination, and I'm a libertarian now, and I'm a free market guy, there's
Right.
still a lot of opportunity. People should call you on that if it doesn't work out in Arizona.
Right. Absolutely. Yep. If you're interested in getting into the industry and Arizona is no longer a state that you're interested in, obviously, or if you are not via licensing, but through partnerships, obviously we can discuss that. Otherwise, there are a lot of neighboring states like New Mexico that just legalized adult use as well, where you can apply. It might be an easier barrier to entry there.
I can't tell you how many people I've sent to Oklahoma and California, but that's okay. We can get into that later. And MITA USA is going to get into that. We're going to jump into the mix. Caleb, go ahead.
If I could.
Oh, we already had the close off, so.
Oh, you did?
Thanks again.
All right, did I miss anyone?
Dimitri, can you hear me? Can you hear me?
Dr. Humble.
Hey, I just was going to suggest, Dimitri, if you could possibly do a group email with the participants on this panel, because I know most of you, some I don't know as well as others, but if we can kind of keep this pool of people here in dialogue via an email group that MITA can facilitate, I think, rather than kind of come together occasionally like this, if we can be in more or less ongoing contact here through the finish line in December, I think that would be of great value, not just for all of us, but for everybody else who that we're going to be talking to.
Caleb did that old Jedi mind trick and said he was going to send one out.
Okay.
Sure.
Yeah.
All right. Well, I'll make it.
Do that, just listening to Caleb and Maxine, and we're in this circle of lawyers like John, Janet, Gary, and I. But wow, I think if we could all sort of have that ongoing dialogue moving forward for the next month and a half, there's no question. I think that'd be of great value for everybody.
Well, October 27th, we hope you're better by then. We have a big meeting, 5 to 9 at MITA. We'll be probably discussing social equity as well as a topic of conversation. So we'll start there.
Yes, I am sitting here with COVID. So my brain fog, it's the brain fog.
No. You look great, man. And you always do.
Thank you.
Thank you, Tom, always, and everything you do for the community.
Thanks.
And it's in the spirit of Michael Weiser that we all keep going, of course, because he's the one who taught me more about probably, well, we don't need to get into that, but always remembering Mike. Dr. Humble.
I'm gonna use my last couple minutes in a way you don't maybe expect. I honestly want to speak to my former colleagues at the Arizona Department of Health Services, Tom, Don, Sheila, Carla, and say, well done. I mean, you know, I've been super critical of a lot of things over the last 18 months in the agency, in other areas, but I think they did a pretty good job here, capturing what little guidance that they were given by the statutory requirements. I will say, if I could urge them to change one thing in the final rules before December 1st, it's push that deadline back into February for the applications, to recognize the fact that many of these county courts are way behind on their expungements, and it's only fair, you know, to the prospective applicants to be in control of their own destiny, and they're not when the courts are so far behind. So good job overall. Well done. Congratulations, but please move the time frame.
All right, with that, I don't know when the next time is that we will be together publicly like this. We will be together October 27th, and I invite anyone who's out there to attend and join us at MITA. Grab one of these individuals. They're outstanding members of our community, always willing to share, always willing to teach, always willing to make things more transparent, which I realized as an ex-prosecutor coming into this industry, one of the main reasons for ending prohibition was to open the curtain, you know, let things happen in a transparent, accountable manner. So all your guys' participation in this whole process, you know, shows your commitment to that. And our commitment to that is absolutely firm. So we will see you all in MJ BizCon at the North Hall, where all the cool kids are at. We'll be launching MITA USA there. And come join us on the couch, talk about MITA USA's philosophical approach to having a national trade organization. And with that, thank you all very much for participating.
Good job, Dimitri.
Thank you.
See you soon.
Everybody.
Take care.